I'd like to call into session the May 9th meeting of the EOTC at 4:08 p.m.
On the call of the roll for the meeting of the Education Outreach and Training Committee for May 9, 2016, Member Pilpil? Pilpil present.
Present.
Chair Hyland?
Present.
Hyland present. We have a quorum. At this time, I believe we're waiting to hear back from Supervisor Marr's office regarding their attendance regarding item 2 and 3. Would you like to take item number 4 out of order this time?
Mr. Hartz, would that be okay with you? Just give me a few minutes. Okay, thank you. Yes, let's go ahead and do that.
Item number 4, file number 15020, hearing Policies and Procedures Guide, how to respond to requests for public records. Just as a background, the committee has been working on creating a guide for departments to make the process of responding to public requests standardized and easier to understand to the members of the public.
So if I may?
Member Pilpel?
Thanks. So I prepared this short document that's in the packet starting at page 52. It's just under 2.5 pages, really only 2 pages of content. And I would disagree only slightly to say that it's not intended to be a comprehensive guide to departments about how to handle public records requests. I sort of intended it as guidance to departments on best practices. I was not trying to rewrite the ordinance. I wasn't trying to rewrite or restate the Good Government Guide. I was just suggesting processes and procedures that departments should have, kind of in my view, and hopefully in the view of the committee and the task force, about how to handle public records requests. I'm certainly open to changes, whatever we want to do with it. If the two of us think that this or some version of it works, we could forward this to the full task force. Ultimately, I think it would be good for the task force to adopt some version of this and distribute it to department heads for their guidance. It certainly doesn't prescribe everything. It's not intended to particularly aid in the handling of complaints, just sort of lay out good practice as I saw it. And it's certainly not comprehensive, and as I say, I'm open to any chit-chat you want about it. That's my introduction.
Yeah.
Thanks.
Thank you, Member Pilpel. No, certainly some work has gone into this, and I appreciate the detail. I think the timing is going to be good, too, I'd like to get this to the full task force soon, especially with the new members coming on board. This will almost be like a précis for them to see how a sunshine request might move through a city department and, give the newer members an idea of what the process that they're here to represent is all about. It's also interesting to note that there's, some other efforts underway, I believe at San Franciscans for Sunshine, that I think are looking at something more comprehensive than this. I'm guessing, and it'd be interesting to maybe even get their input down the road. But I think as a working document, it's probably a good start. My vision for this, when I came up with this item, I guess, gosh, going on a year back now, was to have something even more concise, almost in bullet form, if you like. And this can certainly act as the backing for that eventual document. I'd almost like to see something that both a complainant and a respondent can look at, almost like a placard on a desk. Sunshine information requests here. Here's what you have to do. Boom, 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 boom. And just kind of give someone who may have absolutely zero knowledge of the process just a snapshot of how to go about it. That's my eventual. That's the form I'd like to see it get to, if at all possible.
I guess I hear you. I guess I didn't fully comprehend that when we last discussed it. I don't think that this particular content can be boiled down to a page with bullet points because I think there's just too much stuff there and it kind of needs to be there. I phrase this in terms of departments should do things, so it's not that they must or shall, but it was sort of guidance in that way. I now understand what you're suggesting to be a bit of a different document that's sort of a how to file and how to file a public records request. I thought of this more in terms of what departments should do on their end. I don't think there's any, what's the word?
Help for the complainant?
Conflict. That was the word I was thinking.
Okay.
I don't think there's any conflict between this and a guide to requesters or
Right.
just a guide that says, here's how you file a request and blah, blah, blah. This was more the other side of it.
Got it.
I'm happy to prepare that as well, if
Yep.
you'd like. We could hold this and package them together. I could try to work on that, as time permits. Yeah, I mean, I guess that makes sense, is to do that as a separate follow-on item.
Okay.
Because that'll also take some time.
Right.
We should probably also, prior to adopting this finally at the full task force, send it around to at least a couple of departments and maybe the city attorney and see if they have comments on it.
Yeah, I agree.
I don't want to misstate the law or anything.
Yeah.
But I'm happy to take on that other piece as well.
Yeah, I think the other piece would be an integral part of it because so much of the type of documents you work on are designed for the city department. But I would love to see something go out to the complainant. The novice complainant that has never has the courage, first of all, to show up and try and even file a sunshine request.
Right.
Just to give them some guidance, like, okay, you can do a sunshine request. This is 5 days. You can do an IDR. That's 48 hours, whatever it is, and just kind of give you the breakdown of how to do it and what to expect, to help them phrase a request very tightly with detail, and not get too out of hand that the department can't comply, et cetera, et cetera. I'd be interested to hear from Mr. Hartz if he has any comments on this topic at this time, since he's been on the complainant side.
Can we consider this public comment at this time?
Yes, let's take some public comment on this topic, please. Yeah.
Seems rather strange to be talking through a microphone with the four of us. There are a couple concerns I have. On page 52, the first page of the memorandum, the third paragraph says each department head should designate a primary staff member to receive and respond to public records requests, et cetera, et cetera. The problem with that is one that I have discovered, which is if you send it to a particular person other than the department head, and it ends up getting referred to the Ethics Commission, they will simply deny it because they cannot hold anybody except department heads and elected officials responsible. So, like with the library, I send them all now to Luis Herrera. If he wants to delegate that to Sue Blackman as the custodian of record, he's certainly entitled to do that. But it still is held responsible because he designated to her, and if she didn't fulfill it, then he can be held accountable. And if it's referred to ethics, then they are able to do something. Other than that, we've found in the past everything that is referred to ethics, if it does not clearly list an elected official or department head, they simply just say, well, we may find him in violation, but we can't do anything regarding this person because they're not one of the people who is subject to this. And the second concern I have is on the responses. I think you should put in there.
Are we still on page 1?
Hold on a second. Let me.
Or second page?
Page 58, item X, I guess it would be. Department's response to a records request.
Sorry, can I just interject for a sec? That's the Department of Emergency Management's policy. My thing was only the first 3 pages.
Okay.
Oh, those are like templates, if you like.
Does it address the issue of responding to a public records request? Your memo?
It talks about IDRs.
Yeah.
Okay. Well, the point is,
Go ahead.
there should be something in here indicating to the respondents that not responding to a written request with a written denial, even if there are no records, is a violation of the California Public Records Act. Subsection 4, request for records and agency response. Under A, procedures, the last line says, finally, when a written request is denied, it must be denied in writing. So in other words, if they either are saying we have documents we're withholding, or we have nothing responsive to the request, it must be in writing, or it is a violation of the California Public Records Act. And I think if you're giving guidance to the respondents, which are all city agencies and city employees, they should be aware of the fact that they can be subject to that violation in addition to the sunshine.
Thank you. Just in response to that, since we have those topics here, I'm wondering if, and again, I don't want to sound too lectury in this document. I'd rather this be something that departments, and I like your idea about sending it to departments to get them to get some input, but this should almost be like a Cliff Notes in their sunshine requests folder where they can quickly look at it. We could put some stronger language in, such as, all sunshine requests are ultimately the department head's responsibility. You may choose to delegate to a custodian of records. Start with that. It'll catch department head's attention. I think that's a good lead-off sentence in paragraph 3, for instance. We could also put Mr. Hart's suggestion about, you must respond to all written sunshine requests equally in writing. That response may include we have nothing, or we do have material, we're going to withhold it, but a non-response would deem to be a violation of the Charter and the Brown Act, et cetera, just a friendly reminder, something like that.
Yeah.
I mean, something not too, lectury, but just to, assume you have a new department head that's coming on board. It's their 101 to sunshine request. That's kind of, the tone that I'm trying to achieve here. Before I answer that, do we have any other public comment on this topic?
Hello, my name is Summer Johnson.
Yeah, Ms. Johnson.
And I'm dedicated to politics and in these public policies is that has a lot to do with the juvenile delinquency that has a combination of standing orders, and I just turned in a lot of the paperwork that has included with the policies. I have already wrote on there about the inclusions with standing with the police department, and this includes with majors of June 2001 to 2000.
Ms. Johnson, we're talking about this particular document here. Did you have any comments pertinent to this document?
Yeah, just my comments to this is that we are misunderstanding a lot of the procedures that I have requested on policies. And this is what I'm inclined to with this recommendation, because I just turned in a lot of these decisions and policies.
Thank you for that.
And we'll have better policies here. That's
Yeah,
okay.
that's what we're trying to get to.
So a couple of points. I can certainly add, and I have no problem saying that department heads, something like department heads, are ultimately responsible for records requests filed with their department. I think it's important for us to say, though, that they should designate a person because in day-to-day practicality, the department head isn't going to go search for records in remote locations and ask every staff member. They're going to designate someone, but I think we should attempt to hold them accountable for that, so a department head can't say, oh, well, I got it and we sort of lost it or whatever, or the person that handles that was out on vacation or leave, so it just sat for a few days. So that's why I was trying to have that designation, but I have no problem reminding department heads that they are ultimately responsible.
And why don't we just say custodian of records in there? Are we not saying that?
Well, I didn't want to make up terms or use terms like that, because I think...
Doesn't each department have to have a custodian of records?
It's not entirely clear. I mean, the language of the ordinance says that every city employee is a custodian of the records that they hold.
I see. That's pretty nebulous.
Right. And I didn't want to create some new concept that's not in law about someone doing this. So that's why I didn't give it a title, but just to describe the function.
I mean, you could put there, some departments labeled, call this the custodian of records, just suggesting the other departments.
Yeah, I was trying not to use terms like custodian of records or IDR or EFNQ. I mean, some of the shorthand that we use, I wanted to keep this as clean as possible. But let me take that comment and see if I can.
Yeah, I mean, again, look at this from the terms of the freshman department head that's coming in and has a sunshine folder thrown on his desk. To be able to pick it up and just go through it, bang, bang, bang. Okay, this is what I got to do.
Yeah, I mean, I would assume in most cases there is a department head guide that was put together years ago for the city generally, and I think it has some section in there about sunshine. Department heads are subject to the training requirement, which kind of bombards them with stuff. I would suspect that a new department head will probably be advised by their city attorney that when you get a request, you handle it. There's a process for that. Thank you very much. And they probably, I don't think they know or care that much. And they only know or care, as Mr. Hartz would know, when they're called before the task force or when something else happens. Other than that.
So precisely, I like your idea about floating this by the city attorney.
Yeah.
And if we tell them that this is something designed for freshman department heads, what do you think? Are there any points of law or anything else that you would recommend we include, or have we overstepped? I mean,
and again, I'm happy to do that.
That's the kind of tone we're trying to set.
The other point I wanted to make on responses, we can certainly put something in here about, I thought it was pretty obvious, but perhaps it bears reinforcement, that a response is needed even if there are no records, and a response saying that there are no records needs to indicate who made that determination.
Or even, hold on, I think we have records, give us another day or give us till this date. Just some communication, something just to acknowledge the request.
Okay. Some of that's in there, but I will try to spiff that up a little bit. I think that's good. Again, I will seek some further input from folks. I think we can try this. Again, this is not supposed to replace any of the other training that we do or the Good Government Guide. If we need to fix this in the future, I think we can. I think it's good for us to be sending letters and to giving guidance to departments. And I have no problem taking on the other project to create a relatively short guide to requesting public records in the city. I would ask Victor that if and when we send this to the full task force, that we recaption the item with the file number as just the heading that I had on the memo, guidance to city departments regarding public records requests.
All right. Two more things, Member Pilpel, before I forget. The second to last paragraph on page 2, where you talk about departments should be mindful that members of the public may not know the internal practices, etc. Mm-hmm. I'd like a little stronger language in there saying that it is the person assisting the member of the public's duty to point them in the right direction of that information should that department not hold it, or perhaps help them phrase the search string, something along those lines. That because so many times, that violation comes up with departments.
I didn't do this in any particular order. What I might do is take that paragraph and put it ahead of the big paragraph at the top of page 2, because that talked about assisting, and maybe I can have a little bridge there about the whole assistance function.
The other thing what I'd recommend is, again, this I'm trying to make this more palatable. Right now, it's informative, but it's paragraph after paragraph after paragraph, and where was that bit on? I'd like to see a couple of titles in there. For instance, information requests, and then IDRs, and then just kind of, following a process. We could break it down because on the flip side, when we do the complainant side of this, I want to be able to say, so you have a sunshine request. How do you go about it? And kind of the steps you would take,
Right.
and the things you need to be aware of, and et cetera. So try and think of, again, make it friendly on the eye. Throw a few titles in there.
Okay.
So
I mean, I hear what you're saying. I'm not sure if this first pass may do that, and I was trying to keep this short and not end up being 5 or 10 pages of
No, it's
stuff.
okay.
But I thought that the primary audience for this particular document was department heads and their assistants and people that handle records requests. It's certainly not, a private document. It's a public thing, very much so.
Right.
But I didn't see this as being, I saw this as being a slightly more technical document than a guide to the average requester, which I think needs to be less technical.
yeah,
I hear you.
And that might be a separate piece anyway. But
And there is stuff in here that doesn't now exist. The thing about acknowledging requests, they're not really required to do that. We're just saying it's good practice, informing the person that they have options in recourse with the supervisor records, with the task force, and with the court. Asking departments to prepare their own guide to records requests.
Yep.
I mean, there's some things here that we're kind of suggesting as good practice that doesn't exist now.
and then one last thought on page 3.
Yeah.
Where you talk about setting up a general email address like mayor's sunshine requests at SF.gov. I'd like the second piece to that to be and a link on your website to sunshine requests would be great.
Should we not have?
Well, if you do, put it with that maybe.
Yeah, okay.
Kind of tie those two together. I know you've got as far as email. I know you're not quite on the web pages yet, remember PillPill, but that would be useful for, I'm just kidding.
I've heard that there are now color televisions. I'm not
Yes.
familiar, but if you say so.
They exist.
Yeah, let me try to make those edits, and we can make further tweaks at the full task force.
Okay, good. I think we got through some good material on that.
And again, this is not set in stone. If we need to change it, if the law changes, if practices change, we should be able to periodically review this. I mean, ultimately, we should build a small library of documents that the task force maintains.
Right.
That's not like the whole good government guide, but that we have our own sort of set of guidance.
Yeah. I mean, quite honestly, having been through the ethics training myself, and it's quite long, rather sunshine training, I wonder what the takeaway is from department heads, I mean, it'd be nice if they could have a 2-3 page, guide that just is perhaps endorsed or approved by the city attorney's office, and everyone runs off the same sheet of music. I mean, wouldn't that be great? As a start.
Beautiful dream.
Wow.
Yeah.
Exactly. So, can we make a motion to continue this?
I was thinking that we could send this particular version with the edits that we talked about to the full task force, and that I would create the other thing as
Okay.
a separate item. Are you comfortable with that, or do
yeah,
you want to
we
keep
can
the
do
whole
that.
thing?
I think it's close enough at this point.
Okay. So I think the motion is to approve as amended and discussed with the guidance that we just talked about, and forward it to the full task force for their consideration
Okay.
at a future meeting.
Yeah. Any public comment on that?
And also move.
Yeah. I'll second. Any public comment on that? No? Okay. Seeing none? All
May I
right.
ask which meeting of the full task force you'd like this to be?
Probably not before July.
Well, if I can get it ready for June, we'll try. If not, it'll be July.
I think June looks pretty full already based on the agenda we have.
Let me try to get it done, and then you'll
Okay.
be able to decide.
So let's call the chair. And Ms. Young, do we have an update from Mr. Marr's office?
May we take final action on this one, then I'll provide your update.
Sure. Okay.
There be no additional public comment on that motion to to approve the guide as amended and refer it to the full task force review to be determined at the call of the chair.
Without objection?
That motion passes without objection. I have received word from Supervisor Marr's office, and they have stated that due to a scheduling conflict, they're unable to send a representative to today's meeting.
A scheduling conflict that they just found out about? That's disappointing, given that this whole meeting was about their office attending.
Well,
Mr. Hartz, would you like to approach?
should we call the item first?
Well, I guess,
What to do.
yeah, but I just wanted to get his feedback, whether he'd like to proceed or postpone it.
We
till-
are discussing item number 3, file number 15072, hearing on status of order determination. Complaint filed by Ray Hartz against Supervisor Eric Marr for violating Administrative Code 67.25A. This matter was referred to the task force for discussion on the development of methods to prevent future mishandling of immediate disclosure requests.
I'm sorry, did you say item 3?
Yeah.
Yes, this is the item that Mr. Hartz is here for.
But he's here for item, oh, I'm sorry, I'm looking at the wrong numbers. Yeah, carry on, okay.
Mr. Young?
Okay. Yep.
One for you and one for the record and one
Yes.
for each of them. Ready to go?
Yes, please, go ahead.
Okay. The document that I've just passed out to you is a list of all of the responses to this particular IDR. And Eric Marr's office is nowhere on there. He has still not responded to this IDR, although it was 9 months ago or 10 months ago. It was a March request. So basically, it was kind of ironic earlier, the previous item, when it said, don't they know that they need to respond? And the answer is apparently no. And I would like to see you recommend that this be sent back to the full task force with the recommendation that an additional violation of 6734 willful failure shall be official misconduct and be forwarded to the Ethics Commission. And I will reiterate what I said on the previous item. The fact that they did not respond at all is actually also a violation of the California Public Records Act, which makes this even more egregious. Mr. Lim, when he came to the testimony, didn't really have any sort of a rational reason why this was not responded to. He just basically said it got lost, or we get a lot of emails, or some vague thing. And in the order of determination, it said Mr. Lim acknowledged that the response was not provided to the complainant and that steps have been taken to ensure that the oversight does not occur again in the future. Well, if they can't even respond to this, then I think we have a real problem here. I've recently, at the last Ethics Commission, filed a complaint against Supervisor Farrell because in this same request, what I did is I filed the request with their office. I called their office the same day, told them the request had been sent in. I called them 2 days later when they had not responded and told them that the IDR was not responded to. I called them again at the end of the 14 days, even though they hadn't invoked the extension. I called them again at the end of 30 days and told them that it was there. I went before the Board of Supervisors on 3 separate occasions, having to wait for several hours each time, and put up a PowerPoint slide showing each of the supervisors who had or had not responded. And I even at that meeting, I said I was really surprised to see Supervisor Marr on here. But the reality is he has still not responded, his office has still not responded to this complaint, or to this IDR. And I really don't think it's from a lack of understanding that they are supposed to. Obviously, Mr. Lim, in his statements to the full task force, said that he was going to make sure that things like this didn't happen again. But then he went right back and failed to even send a response to this. As you can see from that list I passed out, all the other supervisors eventually responded. The very last one at the top was Adam Mathias, and I can't remember whether that was Supervisor Farrell's office or London Breed's office, but that was 6 months after the fact. So basically, I don't really see any point in continuing this for another hearing. They can't even manage to make it to this meeting, and I don't think they're showing good faith in the way they're dealing with this at all.
Thank you. Mr. Clerk, just to summarize, just make sure I have this correct. This is something that the full task force heard about a year ago. Is that right? I think it was June.
I was on June the 3rd.
Yeah, almost a year ago. Okay. And we found violations, and it was referred to EOTC.
Yes.
Has it ever hit compliance?
No, this was referred to the Education Outreach and Training Committee.
Sent here.
We attempted to schedule this at the previous meeting of EOTC. However, that meeting was canceled.
Right. Mr. Member Pilpel?
Yeah, a couple of thoughts. I mean, I don't disagree entirely, but I'm not sure what the best course of action here is. I think that the failure that the task force found and the violation stands. I'm not sure. I really would need to think some more about whether failing to show up at a follow-up hearing or demonstrate compliance with the order itself somehow transforms an initial violation into a willful failure. I'm not sure that it does. Perhaps I wish it did, but I'm not sure that the language of the ordinance does that. Nevertheless, I'm troubled by their absence and failure to send anything. I'm also noting a couple of other things. In the packet, I didn't see a notice to Supervisor Marr's office that this was coming.
It was provided.
Okay. Can we absolutely include the notice of the subject hearing in the packet in the future so that there's no question that they got it? Where I'm leaning on this is to continue this to the next meeting of this committee, to issue a notice to Supervisor Marr's office that we do intend to hear it next time, that we, in advance of that hearing, we would like a letter or a memo from them explaining exactly what steps have been taken to ensure that this oversight does not occur again in the future, and noting very clearly that if they fail to appear at the next meeting, that the committee would likely forward this to the full task force for further action, so that they're very clearly on notice to that end, more so than they were for today, and with clear consequences noted.
Okay.
And
Let me stop you there one second. Mr. Clerk, can you quickly summarize what, if any, communications you've had to Eric Marr's office and responses regarding, any changes in procedures, any efforts to? Has there been anything from his office acknowledging any efforts to comply with this order of termination?
Notices of hearing are sent approximately 3 weeks prior to the meeting. In terms of a response, I do not recall receiving any additional responses from the Supervisor Marr's office.
So the only communication we've had from the SOTF to them is notice of the last meeting, which was canceled, and this meeting?
Yes.
Okay. And no responses from them on either case?
I do not believe so.
Okay.
So,
And just to complete that thought, obviously Mr. Hartz has been in, I'm going to guess, a fairly constant communication. Would that be an accurate summary? Okay. So, I think they're aware that this hasn't been dropped and swept under the carpet, and I like where Member Pilpel was going, to maybe send them a strongly worded letter from us, saying, here's the consequences. But on the other hand, I think it's unfair to Mr. Hartz being dragged in here, and especially them not showing up at the last second with a scheduling conflict is pretty flagrant disregard for what we do here. So
I'm not disputing that. I just, for whatever reason, I think that in our notices to respondents on follow-up issues, whether it's at this committee or compliance, I think we could be more clear that it's in relation to the order of determination or any other directions that the task force or the committee gave, and that we want something in writing from the respondent explaining how they're dealing with that. Sometimes we get it, sometimes we don't, but I think we need to be more clear and more strong from now on that if we don't get that the committee or the task force may take further action, and that's ultimately what we want. We've already found the violation. That's not going away. We want to know that they've corrected the practice, whatever it was that we sent off to committee. And I'm not sure that we're always getting that. And in this case, we didn't get anything.
Yeah. And I'm just looking at some of our previous, other, I guess, notices to respondents. It's a pretty standard template we use, isn't it?
Yes, it is.
And it doesn't really lay out what Member Pilpel just referred to as to, this isn't. Well, I mean, I guess it probably acknowledges the order of determination that it's linked to, but it probably leaves it at that.
The first notice that is sent out 3 weeks prior just provides the title. And I believe recently I have been adding an additional note, as you see on the agenda. I tried to provide a short description of the history of the matter.
Useful.
Right. And I wasn't really intending to take issue with Victor, with this Victor on this, but I think the way the description is here, it suggests that we at this committee would somehow develop methods to prevent future mishandling. No, it's that the respondent needs to demonstrate that they've changed their procedures to prevent future mishandlings or whatever it is that we've asked for. I mean, I think we need to put more of the burden, to shift that burden to the respondent, because they're the ones for whom a violation was
Actually, I
found.
have to agree, Victor. That certainly reads like we're doing the work. So we need to tweak that language going forward and refer the matter to the committee, period. The respondent is responsible for developing methods to prevent future mishandlings of IDRs and presenting that at the next meeting, something like that. Just
I
to,
may make a suggestion that
And
we
the
should-
order also.
that's
we
what
need
I
to-
was
we
going
need
to
to buff
suggest.
up
That
the whole
we
thing.
need the orders of determination and the directions
need to be tight.
from the chair to the respondent needs to be clearly made at the task force meetings.
Yeah.
Otherwise,
That's something we've been working on for a while, haven't we?
Yes.
In the last year, I'd say.
But clearer and stronger, and we need to look
Yeah.
at that language before it finally issues.
Yeah, Chair Washburn and I have actually been tweaking them somewhat, but I
Okay.
think there's still room for improvement in that area. Okay.
Anyway, I'm sorry to get off
Yeah.
on that, but I think it's important for fixing our process going forward.
Yeah. Mr. Hartz, did you have any other further comments on?
I do.
Try and contain. your
Look at the
enthusiasm.
agenda item, file number 15072, hearing on the status of the order of determination. The status is it has not been complied with. And you can talk about education and outreach and all this. I think it's kind of ludicrous, given that Eric Marr has been a supervisor for a number of years. His staff is very well paid. He got an extra staff member this year in the budget. So the bottom line is they know what their duties are, and they know they have a requirement. And as I said, this is also a violation now of the California Public Records Act, because they have failed to respond in any way. They didn't ask for an extension. They didn't give me a response. They didn't. They came to the meeting, didn't have an explanation as to why they didn't respond. Now they don't show up today.
Can you refresh our memory, Mr. Lim? And actually, I didn't see his name on this list, but that's
Well, that's what I'm saying. It's
you're
not
just-
on the list because I got nothing from Eric
Okay.
Marr's office.
Point taken. And on June of 2015, what was Mr. Lim's? Was he the custodian of record number 1 and number 2? What did he tell us?
He didn't identify himself as anything except an aide to Eric Marr, and what he said was, yes, we acknowledge we didn't reply.
And therefore, we found a violation, and
Right.
nothing's happened in a year.
Exactly.
Okay.
And I mean, as I've laid out before, Eric Marr has had plenty of notice on this, including I sat for 2 hours or 2.5 hours each time before the Board of Supervisors, put up an overhead projection with his name listed on it and saying, still hasn't responded. So, I mean, this is knowing and willful. I mean, he knows that there was an IDR out there. He knows he has a responsibility. And one thing I'll add in here is with my complaint regarding Mr. Farrell, the deputy city attorney wrote a letter to the full task force relating to the Ethics Commission's guidelines for willful failure, which you all talked about and said you felt was too strict. But what he wrote was clearly what Mr. Maher has done. He knows he has a responsibility under the law. He knows he has an obligation to respond, and he failed to do that, and he has done it all along. The only thing that he has done is send Mr. Lim to the Sunshine Task Force hearing. That's it. Everything else he's ignored.
Mr. Chair.
Member Pilpel?
But to be fair, we have found violations of this section and other sections, and in fact, stronger and bigger violations, arguably, that the task force did not find was willful. And I am not sure that I would, a year later, add to a previous violation that it somehow became willful.
That was not what I asked. I asked.
Sorry, we're in discussion. So.
Well, don't make stuff up, Mr. Pilpel.
I'm sorry. Could you?
Mr. Hartz, hold on one second. Carry on, Member Pilpel. Finish your thought.
So, I'm not saying that there was no violation. There was a violation. We found a violation last year. What we're trying to do is follow that up and prevent.
No, you're not. You're trying to evade it.
Mr. Hartz, please don't interrupt. Just wrap it up, Mr. Pilpel.
We're not. I'm not sure that at a follow-up meeting, and that's what this is, it was referred for follow-up. I think our task here is to, and maybe the language should have been, to ensure that the Office of Supervisor Maher has developed methods to prevent future mishandlings, right? I think that's our task here. I don't think it's to find another violation. We already found the violation. I don't think it's to find that the violation was willful and consider referring it. I think it's to get that thing fixed. And I don't think there's any tool in the ordinance other than our asking and requesting to try to make this happen.
Well, let me ask you this procedurally, and Mr. Clerk, if you'd like to chime in, feel free. As far as the progression of, order termination violation was found, the original IDR still has not been responded to, so that order of termination has not been complied with in my eyes. Should that not go to compliance and have them rule on it, or perhaps even the full task force? That's my first question.
I do not believe that was part of the order.
And again, that's if we'd been writing tighter orders of termination, we may have included that at the time. Yes. But that aside, is it not our general practice when we have an order of termination, we usually refer it to EOTC or compliance, and especially when the respondent is standing up there saying, yes, here's the documents, we're going to keep working with them, that usually goes to EOTC to make sure that everything is, that the policies are adopted and gone forward.
Well, if there were missing documents, it should have been sent to compliance and amendments and not EOTC.
Well, that's what I'm thinking here. Why did this not go to Member Pilpel?
Because the reason it was sent here was to see about training. It was about developing methods. It wasn't about getting a response, because I believe, if I recall correctly, that Mr. Lim got up at the meeting and said, we have no responsive records. And I think we probably said, well, you should have sent that to the complainant, and we either asked him to do so, or it was made known to the complainant that they had no responsive records. So the issue on follow-up wasn't finding records or sending him a response. It was to prevent future recurrences.
Mr. Hart,
that's why it was sent here.
Can you answer that to that question?
I think Mr. Pilpel is really kind of being ludicrous in the sense that he thinks he remembers better what happened in a meeting regarding my complaint than I do.
Then you tell us.
Mr. Lim did not respond. He did not give a valid reason why there was no response, and he was given an order of determination to respond. I, at the time, asked why it was being sent to EOT, why it wasn't being sent to compliance and amendments, and that question was completely ignored. But the bottom line is, what good is this if you're simply going to find some way of saying, well, he didn't comply, and that's okay? Because that's essentially what you're saying. You're basically saying it's okay, he didn't show up here.
No, I'm personally trying to get you to get your answer, number one, and secondly, to hold them to account. And how to do that together most efficiently is what I'm trying to get to now.
And what I asked you for in my presentation was sending this to the full task force with a recommendation that they find an additional violation of the willful and knowing and willful, and then send it to the Ethics Commission. That was what I asked for. I didn't ask you to find that, and Mr. Pilpel's trying to say that's what I'm asking for, and I never said that. I said...
And you're within your rights to ask that. Okay, that's noted. Got it. Thank you. Is there any... well, I guess we'll take public comment after. So there's several ways we can handle this. I'm trying to think of the most efficient... and fair. I'm a little bothered by the fact that as a body we've had zero communication in the last year with Supervisor Marr's office, other than notice of, meetings. There's nothing we've sent them saying, why are you guys not, taking care of this? Do you know that you have to? We said nothing to that effect, right? I mean,
I was reviewing the minutes from that date.
Okay.
And just to summarize, Mr. Lim acknowledged that the response to the IDR was not provided to the complainant, and that steps have been taken to ensure that the oversight does not occur again. And then in the order, Chair Washburn referred the matter to the Education Outreach and Training Committee to discuss possible methods to prevent future requests of public records from being lost. In addition, it is requested that the clerk of the board distribute any recommendations that may result from the discussion to all members of the Board of Supervisors.
Right.
So my understanding of this, it was sent to committee to discuss methods to improve their public records response.
And typically that happens because there is some feeling that they are going to comply. I mean, that's been my experience the last 4 years. That clearly hasn't happened.
Well, a couple of things. I think this complaint came around the same time as we had several other complaints about various offices not responding on a timely basis to either a regular records request or an IDR, and we had discussion about email practices and how the offices may be overwhelmed and blah, blah, blah. And I think we haven't yet really put to bed the issue of how supervisors' offices in particular should handle records requests and IDRs in particular, and to the extent that there's a good practice that comes out of that all of the offices should implement that, and the same thing with the clerk of the board. I think that issue is still sort of hanging out there, and we haven't fully wrestled with it. The other point I was going to make, going back to this question of a willful violation and a possible referral to ethics and all that, playing out that scenario a little bit. I mean, we just went through that exercise with Steve Cava. We're going to send that referral shortly. I disagreed, but in any event, that's a big deal thing, right? I get that that's a big deal thing. Hopefully the Ethics Commission will take that seriously, et cetera. I think the task force is in a good place when we use that power to refer selectively and for things that are high profile and really matter. I think we are not in a very good place when we use that opportunity to take an untimely response or a lack of response to an IDR where there were no responsive records and send that.
No, I agree. I mean, those two cases are black and white.
Right.
I mean, I agree with you.
So I'm trying to find a lesser thing that we can do that's meaningful here.
Here's what I'd like to do. I'd like us to send a letter from the EOTC, since that's all we can authorize, to Eric Marr's office, and in that, point out this is from an order determination a year ago. By the time you send this out, it'll be about pretty close to a year. The complainant has repeatedly asked for the information that original IDR. There's been zero response. They were invited to. No, they were requested to be here at today's meeting. And you can put in that we even called you and you told us 30 minutes into the meeting that there was a scheduling conflict. And that we strongly urge him to be here at the next meeting of the EOTC, and hopefully that's going to be not every 2 months, but every month from now. So tell them sometime in June. Just throw it out there for now.
And if we need to schedule a special, we will.
Yeah.
Can I just add to that?
Hold on. Let me just finish the thought here. Just tell them it's sometime in June. Between now and June, we strongly urge you to fulfill the IDR for Mr. Hartz, and secondly, at the meeting, show up with, changes that you've had in your policies of sunshine requests to convince us that changes have been made. Lastly, the last paragraph, I want to say, if you're not able to comply with all of these, this will go back to full task force for consideration of willful violations.
Or other actions.
I think we need at least one strongly worded letter from us.
That's fine.
I mean, you could say the order of determination a year ago was that letter, but that's kind of where I'm feeling on this.
I'm with that. I think the only tweak I would make is where you said that they should show up at the meeting and explain what changes they've made. I think they should put that in writing in advance of the meeting so that the committee and the public can see what they've documented as their changes. And we should be able to talk about that at the meeting with the supervisor's office.
Maybe present a copy of your sunshine requests, how your department handles it.
Their internal practices for how they handle requests, including IDRs, to ensure that things don't get lost in the cracks.
I can bet they don't have one.
What?
I can bet they don't have anything in writing.
Well, then now they'll have an opportunity to put something in writing because they represented to us a year ago that steps have been taken to ensure that does not occur again.
Okay.
They can document what those steps were.
So include that, Victor, in that sentence, saying that, as indicated to us a year ago, steps were to be taken to ensure future requests and IDRs would be handled in a timely fashion. We have not seen evidence of that. Please supply those in writing in advance of next month's meeting.
What good does that do? Any for me? Not those all.
It's a process. We may get to what you want, but I think this is a reasonable first step. And I wish this step had come.
Then you might as well I'll withdraw the complaint because you're just going to fuck around with it.
Mr. Hartz, I agree. I think they should have gone to compliance first off, rather than, being here.
I'm talking about the bias right there where Mr. Pilpel is presenting things
You're welcome.
he thinks he remembers rather than looking in the record. And all he's doing is trying to let Eric Marr off the hook.
He suggested it as a hypothetical. He didn't say that's what I remember. And you're entitled to your opinion, but I think this is a fair course.
Fair to who?
Mr. Chair.
Member Pilpel.
A couple of things. I think that the procedural phase that we're at with this particular complaint is actually less about the complainant and more about fixing the process on the part of the respondent. That's number one. Number two, I agree with the course that you're suggesting, and I'm happy to help make that happen, whatever it takes. And number three, let's be clear that if anything, I am no particular fan right now of Supervisor Marr, who voted a week and a half ago against my reappointment to this body.
Noted.
So, if there's any appearance of bias, it might well be bias against the respondent. So, but be that as it may, I think we're proceeding fairly on the item that's before us.
All right. So can we present that as a motion?
Yes, and let's also suggest that a copy of that letter go to the complainant. So I will so move that we authorize that letter and continue the matter to the next meeting on that basis.
Second. Is there any public comment on the motion?
Good evening. My name is Sally Johnson, and it's a good compliment that I don't want proceeding in delaying because there's a lot of activity going on that has, a lot to do with our surroundings, Earth, and
Ms. Johnson, we're talking about the motion on the floor.
that's what I'm talking about, the motions.
Yeah, may I say, you have a very nice hat today. I like that. Thank you. Thank you. Seeing no other public comment?
On the motion? Member Pill.
Aye.
Pill, aye. Member Highland.
Aye.
Highland, aye. The motion passes without objection.
And Victor's going to draft that. You'll take a look. Let's try to get this out sooner.
Yeah, I
rather
think you
than
got
later.
most of the language.
I will go back to the tape if needed.
Okay.
I will draft the memo and present it to both members for review prior to sending it out.
Okay.
Let's get this sooner rather
Send it
than-
to me just in draft version. I can approve it and
Yeah.
get it moving. Okay. Thank you.
I don't think that was ideal, but I think we did the best we could.
Next on the agenda, item number 2, file number 16008, complaint filed by Michael Trellis against Supervisor Eric Marr, Board of Supervisors for allegedly violating Sunshine Ordinance Section 67.21 and 67.29-5. We did receive an email from Mr. Trellis this morning stating he was unable to attend. However, he'd like us to proceed without his presence.
Okay. So I guess the first thing is a jurisdiction.
Yeah, I mean, I'm just debating in my mind whether we want to go through this and what the outcome might be. I mean, I've read it. I'm prepared to talk about it. Obviously, we still don't have Supervisor Marr's office present, and, I would have questions for them.
Are we hearing this as the complaint?
This is a new complaint.
Okay, so as the complaint committee is what we're doing.
Right.
Okay,
So,
got you. Okay.
so I think we could either hear this as a complaint without the complainant, without the respondent, and make a recommendation, or we could kick this matter to the full task force for a hearing, hopefully with, the parties present if they choose to be, or send it elsewhere. What's your preference?
I think we just hear it as is because this
Okay.
can then be, added to the previous case, and who knows?
No, I mean, they're separate, but they're cumulative.
My point is,
Yeah.
let's keep the pressure on this particular office.
Okay, I will so move that we find jurisdiction.
Second.
Is there comments regarding jurisdiction only? This is only on jurisdiction.
This is Sylvia Johnson. Regarding the jurisdiction, it has the pathics of some of the jurisdictions that certain I could explain a little more with that, a lot more intelligence with knowing the jurisdictions.
Thank you.
Ray Hartz, Director, San Francisco Open Government. Given this is the same type of violation that the task force went through, gnashing of teeth and pulling of hair of not keeping a calendar and not providing the calendar for someone who wasn't an elected official, and that question was raised by the city attorney's office. Here we have an elected official who is not keeping the calendar, is not responding to the request for the calendar. And again, I can't figure out anything. Well, I know why it's here now, because this is complaint committee. It is certainly within the arena of the Sunshine Task Force duties, and it should be sent to the task force with a recommendation for a full hearing before the task force. Again, this.
Mr. Hartz, we're just taking on jurisdiction, but those comments would be salient for the next phase, if you want to.
Okay, well, you definitely have jurisdiction.
Okay, thank you.
Without objection?
So moved.
Neither party is present at this time. you may move directly into discussion.
Okay, thank you.
Shall I?
Yeah, Member Pilpel, go ahead.
So, on the facts before us, it appears, well, first of all, if we do something with this, Victor, can you check if there was more to the Deputy City Attorney's letter? Because I only have the first 5 pages, that's all that's in the file, and it appears to just sort of end there, and there are things missing, the law, the questions. I'm not sure if there's more to it than what we've seen. It appears that complainant Petrellis started asking for stuff in the beginning of January 8th, and did not receive the responsive records until January 22nd, like 2 weeks later.
I'm seeing a lot of back and forth,
There's a lot of back and forth.
and compliance and requests for extensions and whatnot.
Right. So I would suggest, and I can't quite tell what's going on with the text messages. There was some response that said that we don't use text messages, blah, blah, blah. The calendar that we saw, at least the excerpts of the calendar, you have to interpret a lot of things here. It's got a lot of initials and acronyms and not all the addresses that should be here. I guess I'm not sure if the underlying calendar complies with the requirements of 29-5. That needs a little more examination. If you look, for example, page 35 of the packet, Friday, January 16th, 8 a.m., EM, call Campos. I assume that means Eric Marr was supposed to call Supervisor David Campos, but I don't know. 8:30, EM, Joseph Smook, 8:30, Hamburger Haven. Was that a meeting at 8:30 at Hamburger Haven at no specific address? And what was the topic of that meeting? I don't know. 10 a.m., meeting with Tom McGuire, Director of the MTA Sustainable Streets Division. Eric's office, Eric Marr, Peter Lauterborn. What was the topic of that meeting? I don't know. Et cetera, et cetera. So the previous day, 6:30, EMPL, start the year with RDDC event. I assume that means Eric Marr scheduled by or with Peter Lauterborn, who was then his aide, start the year with the Richmond District Democratic Club, but that's only because I know what their initials are. Event where Steins. I don't know where Steins is. I don't know what that is. So, without belaboring it, I'm not sure if the content meets the 29-5 requirements. In terms of the timeliness, this, I do not believe, let's go back to the original. Subject was Marr, Eric, request for your 2015 calendars. So it was not styled as an immediate disclosure request. However, the language, there's interesting language in 29-5, if you'll bear with me for just a moment. For meetings, 67.29-5, sub A, blah, 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 shall keep a daily calendar, for meetings not otherwise publicly recorded, calendar shall include a general statement of issues discussed. Such calendars shall be public records and shall be available to any requester 3 business days subsequent to the calendar entry date. So I don't think we've ever interpreted this section before, but I am of the general view that means that you have to create this Prop G calendar no later than 3 business days after the entry date, and it should then be available for whatever your retention period is, and I think that's generally 2 years. So I think that this falls between the IDR, you have 24 hours, and the regular 14 days. I think that it's basically subject to an IDR, even if it's not requested as an IDR, that once 3 days have passed, you're supposed to have that calendar, and you're supposed to have it available. It's not like something that you just bury in a drawer and you say it'll take us 2 weeks to find it. I think it needed to be made available in response to the request, roughly as an IDR, so long as it was, at least 3 days after the calendar entry date. So I tend to think that there's probably a timeliness violation and probably a content violation as to the 29-5 content. That's just my thinking, again, in the absence of the complainant or the respondent, and I would query both of them about those issues. Does that help you?
It certainly sounds like something that should be referred up to the full task force with her recommendations. I think those two violations are probably good ones, and I think your discussion about, IDR and the 3-day is an interesting one. I think that's open to different interpretations. Yeah. But I did notice in Mr. Petrellis's letters, he said somewhere that he's asking for this information again. So he's I guess, implying that he's received it before, but that he had a computer meltdown, and therefore he was asking for it again, which I guess is his right. But I'm just curious that if they pulled this information together for him in the past in the form of a PDF, presumably, why were they not able to do it again? Or just resend that email,
I mean, on that point, I guess I'm not yet of the view that every department head or every respondent needs to keep every response to a public records request forever in case someone asks for it again or in case someone else asks for it. Mm-hmm. I think there may be things that they need to keep for a period of time. I mean, I think that sort of 2-year retention period for anything that's not otherwise specified actually makes a lot of sense, right? If no one's going to ask for general stuff that isn't required to be kept for 2 years, then you probably can dispose of that. But for things like this calendar, I think you keep the calendar. If you prepare your tax return and you know that somebody may ask you for your tax return in connection with some program, mm-hmm. you keep a copy of your tax return, right?
Yep.
So I just think it's sort of a different burden for responding to a request for this calendar than for hunting for other records that might be kept in a different fashion.
And just to come back to, so this original request, well, I'm seeing March, middle of March, now we're middle of May, but...
Oh, and I'm sorry, we didn't really get a response from the supervisor's office on whether they've complied or not. All we did was get copies of the email. I mean, there was something from Mr. Lim that just said, here's the email chain. Here, Friday, March 11th. Hello, Victor. Please find attached responses I had provided to Mr. Petrellis. Thank you. I mean, again, normally we ask for respondents to explain their side, and not just with documents, but with the story, right? Mm-hmm. Do they think there was a violation? Not? Can they tell us what happened from their perspective? I don't think I'm just missing it. I think we never got it.
It's page 14 of the packet, right?
Yeah. And I'm not saying that these emails aren't genuine. I think they are. But where's their cover letter that says their side of the story?
Yeah.
I'm not saying I'll agree with it. I may or may not, but I'd like to hear their side of the story, not just see the emails. Somebody? Anybody?
So it looks like we're moving towards sending this to the full task force with a couple of violations. I'd like to hear from members of the public on that motion.
Maybe it's more of a notion more than a motion currently, but...
Ray Hart's Director, San Francisco Open Government. Yes, it should go to the task force. Basically, not sending it to the task force is nothing but rewarding bad behavior. You sit here and seem to be mystified by why Supervisor Marr's office didn't send anybody, and I think basically they're thumbing their nose at me, they're thumbing their nose at you, and you're very accepting of that. I have, again, Mr. Lim, if he showed up, probably is not, in my opinion, he doesn't show up because he couldn't answer your questions. And he would have to do what he did at my hearing, which is do a song and dance about it got lost in my dog ate the homework. And
Are there any other violations that you would recommend for the two?
I personally think it's willful. I mean, we're not talking about an individual who has just entered office or aides who have just been hired for the city. These are longtime city employees who've served as supervisoral aides and working for a supervisor who's been in office for more than a full term and basically knows what his responsibilities are under the law. And that's what that letter I talked about in my case was from the deputy city attorney to the task force. It basically said that the Ethics Commission says that willful is you know what the law is and you simply don't comply with it. And that's exactly what's happening here. He knows what the law is, and he's not complying with it.
Thank you.
Chair.
Mr. Pilpo?
So I think the only thing...
Close public comment?
Yes, please.
I think the only thing that's currently troubling me about this particular item, other than what I've already expressed, is that if we send a recommendation to the full task force under our current provisions, the complainant doesn't have to show, which is fine, but the respondent also doesn't have to show.
We don't have to say that.
Okay.
That has just been practiced.
Okay, great. So if we can send a recommendation and request, give the option to the complainant, but request if the complainant has anything to add, they should appear, and request that the respondent appear. I think it's important that we have people show up and be accountable on these things and not just
And I'd actually like to have a respondent show up that is qualified and able to talk to the subject matter.
Well, and I think in this case, it happens to be Mr. Lim because he is the author of all the relevant emails.
Okay.
And, I think Victor talked to him within the hour, so I think he's in the building or was, but chooses not to attend. So that's not good. I don't know what else to do. I don't think this is so egregious as to warrant a willful and a referral. I'm not with that, but I do think it's a problem, and I'm struggling for ways to fix that particular problem.
Yeah, I think at the full task force we can provide some background on our other dealings with Supervisor Marr's office, and therefore, kind of maybe lend some weight to discussion of that as well, if required.
This may be the kind of thing, and maybe I'm getting a little far off as I can from time to time. In addition to the annual report, maybe this is the kind of thing that we provide an interim report to the Board of Supervisors about our frustration with people not showing up at hearings or not being able to follow up in terms of compliance, that our only big tool is to refer something to ethics, and that doesn't always seem appropriate.
Mm-hmm.
But that we want people to take this stuff seriously. So
yep.
I don't know what else to do on that. Anyway, if a motion is in order, then I would so move to recommend to the full task force a violation of 67.21 and 67.29-5, requesting the respondent to appear.
The respondent to appear, okay.
At the task force.
Okay, at the full task force meeting.
And be prepared to provide an explanation or any additional detail you would like to
and
appear
that they should explain in advance in writing and be prepared to discuss the timeliness of their response with regard to the calendars and whether the content of the subject calendars meets the requirements of 29-5.
What about something to the effect of and satisfy the original IDR between now and then? Is that worth putting in? Or
not quite.
Or, there's still information that Mr. Petrelis has not received, from his original, based on the emails I saw back and forth. Like, they're still invoking, extensions, and as Member Pilpel noted, we don't know if they've actually satisfied the request yet.
Well,
So how about something please list or not list, but you see what I'm getting at?
I think, again, it requires some interpretation, but I think that they have probably replied substantively. On page 15 of the packet, the email from Mr. Petrellis, thanks, Victor, I've received the responsive calendars. I think that's what he was asking for, was the calendars. And then he says there's the outstanding matter of the requested text, and there's a response from Victor Lim at the top there. Our office does not conduct any official duties through text messages. I'm not sure exactly what that means, but I will, sort of interpret that to say we have no text responsive to your request. That, too, I think is a timeliness problem, but I'm not sure, and we would need to hear from Mr. Petrellis, perhaps at the hearing, whether that's a big deal to him. I don't know.
Okay.
I was more concerned about the timeliness of the timeliness and content of the calendars.
Yeah, but
The late response that says, "Oh, we don't have any text," that's not doing a whole lot.
right, and I'd like Mr. Lim to show up with the material in hand if he hasn't already provided to Mr. Petrellis by that point. I mean, that's
Well, it appears that as to the calendars, that he got the responsive calendars, and that was the big deal thing that he was looking for.
okay.
Just so you know, you are only provided 10 pages of calendars. However, there are over 200 pages that
It's the
I did
whole
not
year,
print out.
or the whole time frame.
Yes, I did not print them all out.
Yeah.
I did not think you would want 200 pages worth.
Yeah. No, I think what we got as a representative sample is fine. And I believe, without seeing it, that all of the calendar dates are probably included. Again, my concern was about the timeliness of the response and the content of the calendars, not whether there were dates missing.
Okay.
I didn't hear anything from Mr. Petrellis to suggest that there were dates missing or whatever. All right, anyway,
So, Mr. Clerk, if you can repeat what we're going to go with.
The motion is to find a violation of 67.21 and 67.29, 29-5, and to request that the respondent provide a written explanation regarding the timeliness of the response and the content of the calendar explanation.
and this is a recommendation to the full task force.
I think we should put that sentence like, and we're requiring the respondents to appear at the full task force and be prepared to answer questions on their, sunshine procedures.
I believe the procedures is on the last complaint.
Is what?
I think the procedures is more of the last hearing we just had.
Well,
I guess we can bring it
but
up
the
again.
calendar is arguably a different procedure.
Yes,
I think in some ways what you're suggesting is that this might be essentially the hearing on the merits, and that at the full task force we're going to do the equivalent of the follow-up. Because I think what we do more often than not is make the follow-up hearing much later, like this thing that's a year later, and by then
Right.
everyone's forgotten.
Right.
I think if we move all that up and compress the time frame, we're better off.
What I'm trying to avoid is Mr. Lim showing up at the full task force and saying, I don't know.
Right,
And
I agree.
then finding violations, and then, so I'm really trying to accelerate the process.
I totally agree.
Okay.
So I think providing them notice in the committee recommendation of what we're looking for,
about
when we
the-
want it and how we want it, that's all.
How about this? The Complaints Committee has recommended violations to the full task force. So I'm going to put them on notice that they're going to, likely find violations. The respondent is required to appear at said task force meeting and be able to talk to why there were delays in these sunshine requests, and to preferably provide in writing before this meeting to the task force policies and procedures in place to prevent this in the future. How about something like that?
Yeah, and to explain substantively in writing beforehand the timeliness and the content of the calendar.
Yeah, let's get a written document from Mr. Lim before he shows up, just to get him fully
And let's
vested.
get that to complainant Petrellis so that if he has any follow-up,
Okay.
cha-cha-cha, yeah.
All right, I like that. That's tighter.
I don't know if this is going to make it for June, but this will be in the queue.
June's pretty full. This is more likely a July.
Yeah, and we should get this right. I mean, if we do the work correctly in the committees, then things should be more straightforward.
If we get those. Okay. And do you want to take a roll call on that?
On that motion, member.
Comment?
We've actually already had public comment, but I'll allow you to have public comment again since the motions haven't changed, but the wording has. So go ahead, Mr. Hartz.
Again, I think there must be some misunderstanding of what my purpose of using the willful violation, and that is to give a little bit of a light of fire under Supervisor Marr. With Supervisor Breed, the only time she responded to my IDR was when it was at compliance and amendments, and at that point would have gone then with a recommendation to refer it to ethics. And lo and behold, for the very first time, the response came and someone showed up from her office. Basically, I see you setting the task force up for a fall. Mr. Lim knows that there is no penalty for not showing up. He knows there's no penalty for not showing up here. And he knows there's no penalty for not showing up at the task force. And so basically, if I were a person who had done something in violation of the law, knew I was in violation of the law, and knew the only way that I would be likely held accountable is if I showed up, I wouldn't show up, which is, I think, exactly what's happening here. And putting the willful at least lets them know and gives them, I think, fair warning. I think it would be unconscionable. In fact, I would be willing to bet that Mr. Pilpel would argue that because the recommendation didn't include knowing and willful, it would be unfair for the full task force to include that. So I think, very honestly, some of his machinations are designed so that he can later on have a legitimate way of saying we should not make this willful because we didn't include it in our original recommendation. And I think this is more political posturing than it is anything else. I'd be willing to bet you a buck right now that Mr. Lim won't show up, and neither will anybody else from his office. And then the task force will waste an hour of its time arguing about what it should do or continue it to another month. And what's the old expression? Justice delayed is justice denied. In my case, I've waited over a year and 3 months for a response to an IDR and still haven't gotten one. And your efforts did nothing to assist me with that.
Thank you. That brings up an interesting point. I'm wondering if,
Are you thinking what I'm thinking?
well, I'd like to say failure to show up to the task force
Yep.
may
May subject the respondent to a 21E violation. Is that what you were thinking?
that, or 60 may subject the department head to a 6734 violation.
Well, I mean, the department head's Angela, but may subject the respondent
Well, I
to a
meant-
21E violation and/or a 67.34 finding of willful failure.
I like that.
I have no problem with that.
I like that.
I mean, it doesn't bind us to it, but it notifies them.
Yeah, and we're open to any discussion of any violation at any task force meeting or otherwise. But I like putting
We
it.
need to read that back so Victor gets it.
We are adding 67.21E and 67.34.
No.
We're adding a
Failure.
sentence or two to the end of the recommendation that says failure of the respondent or an authorized and knowledgeable representative to attend the Sunshine Ordinance Task Force hearing may subject the respondent to an additional violation of 67.21E and/or a finding that the violation was willful under 67.34, period.
Yeah.
No problem.
Yeah, that's good. All right, and save that template because that's
Yeah,
the kind of
that's good stuff.
That's how I want to get these kind of things written in the future. So we do all this at the committee level so that we can. I mean, if that.
I will work on this and
We're buffing up the templates here.
Yeah, there we go.
work with the members on
Today's all been about templates, pretty much. Yeah. Okay.
that motion. Member Pilpil.
Aye.
Pilpil, aye. Chair Hyland.
Aye.
Hyland, aye. The motion passes without
Thank you
objection.
to Mr. Hartz for that valuable add-on. See, we got there.
Next on the agenda is adoption of various minutes of the Education Outreach and Training Committee.
Well, so that was all the good news. The bad news is I haven't had a chance to do another pass on this, and unfortunately, I would ask that we continue this one more time, and I will give it a go and have edits into Victor.
Minutes from 2011?
Yeah, I know. I did one pass on them. I just wanted to be sure that I didn't miss anything.
Okay.
It's the only indulgence I'll ask you today.
All right, can we at least get caught up through 11, 12, and 13 next time?
I want to get them all done.
All right.
I mean, this is wrong. This is inexcusable, and I
Yeah.
absolutely intend to get through this. So I will move to continue these to the next meeting.
Maybe that's at 6734 from Member Pilpel.
I heard that.
Okay. All right. So moved.
Any public on the motion to continue this matter to the next meeting of the Education Outreach and Training Committee? This is on continuance only.
Adoption of minutes.
My name is Sylvia Johnson, and I think the continues that we have it makes a demand.
Ms. Johnson, this is on the adoption of minutes. Right after this, we're going to have public comment where you can talk about anything you'd like.
All right.
Okay, thank you.
On that motion, Member Pilpil.
Without objection.
So moved.
The matter is adopted without objection. Item number 6, public comment. Members of the public may address the Education Outreach and Training Committee on matters that are within the committee's jurisdiction but not on today's agenda.
Ray Hartz, Director, San Francisco Open Government. One of the reasons that I do what I do, and as often as I do it, and the reason I've got 24 orders of determination is because there is a wholesale disregard of the law. Both the Sunshine Ordinance, the California Public Records Act, and the Brown Act in this city. I couldn't have 24 orders of determination if that wasn't the case. I recently just found that the Small Business Commission was holding meetings. They went through there were no agendas available for the public. I filed a complaint about that, and also a complaint about the fact that they had 4 agenda items after I walked in the room for which they took no public comment whatsoever. And the last item on the agenda was general public comment, and I got up and said that they were required under the ordinance to take public comment on agenda items, and was told by their president that they took agenda items on the things they felt they should. So basically their idea is that they'll do what they want to do. Their minutes are a year behind. I made a public records request for 4 specific minutes over the last year, and the response I got from the executive director of the Small Business Commission was that they haven't had anybody do the minutes in the last 9 months. So now they're going back and they're going to try to figure out who is going to do that, because the person who was there at the time and took the minutes is no longer there. I'll be honest with you, I really am at a loss to think what members of the public who are not familiar with this body's, and I don't just mean the EOT, I mean the task force as a whole and all of its committees, why they would ever come back a second time. You know, I asked for records, and the records I'm asking for, I'm going to tell you right now, the letter that you decided to send on mine, as soon as I get a copy of that, I will be filing a complaint against Supervisor Marr directly with the Ethics Commission, as I've already done on Supervisor Farrell. And when I finally do get that letter, I'm also going to be filing a complaint with the FPPC on both Marr and Farrell, because they were both willfully withholding the fact that they passed legislation and recommended to the full board that they passed legislation and did not want to admit publicly that neither they or any member of their staff had even looked at it. And that was what my specific request was, as what did your staff or you look at when you approved this? And they didn't want to admit they didn't look at anything, because that's negligence. And I don't know.
Hello, my name is Sibyl Johnson, and the negligence on Brown Act and negligence on the PD, and I had not had organizations that, had made requirements, and on my policies, I put emotions with clearance of the duties that they was doing, and that this is regarding that we have laws here, and not to bypass our laws because that's what we wrote for, and we have our other denominations that did not be kind in legislation because it was not, brought for the clearance of intelligence, because there was all been bypassing the whole subject, and they don't realize that they're bypassing their self, because this whole resolution has detained of that. If somebody wasn't over the world and taking peace in the world, then there's nothing. It's that there is, things that we need to know in our common sense about how our human body is made, and we have not even, know about some parts that we have here, and we don't want to deny our human body of what we are, and there's nothing without if we didn't have none. And you don't understand that this progress is organizations that's always been done, in movies and films of years ago. And I think they deny a lot of this progress because of a human factor of newer things that are made in creations. And they try to block out the whole world and make it hell and back, and not even realize they're forgetting out their self and their self-pity and the laws that we have here that nobody even consideration in human nature. And I think that you need to really look at this and put it in our language.
Thank you.
Thank you very much.
Just one quick follow-up. The comments that Mr. Hart's made about the Small Business Commission, has he filed a complaint about that?
Yes, he has.
So we'll hear that in the fullness of time.
Yeah.
Okay. Can we move on?
Yeah.
Next on the agenda, announcements, comments, and questions and future agenda items. There are two pending complaints. One of them is the same subject matter as what we heard too, is regarding procedures for public records. I was putting off the scheduling of that matter until we came up with a guideline developed by the committee. The next one is 14092, Mooney versus Assessor Recorder. We requested a hearing so that we can compare what the Assessor Recorder maintains versus what the state maintains.
So on those two things, I think we should schedule both of those at our next meeting. I think the Supervisor Tang issues are not remarkably different from Supervisor Marr, and whatever discussion and guidance we're going to give about the supervisor's offices and handling of records requests, I think we should just try to knock that out. The Assessor Recorder, that was from a couple of months ago when we heard the first complain about that, they should be prepared to respond, and let's deal with that. In the future, if we have things hanging, can we also indicate what date it was heard at the task force? Because I'm really working with you, Chair Hyland, and hoping that we can move through compliance issues more quickly so that things don't hang for a year. I would hope that we could set like a 6-month deadline, that we would hear things and dispose of them as, committee referral matters in less than 6 months and get things through our pipeline a lot sooner. The other question, unless you disagree? No?
Okay.
That's all good? Okay. And the other question I had, I thought that we had some other items that were referred here about the planning department, police department, all of that. Where did those go?
Those are hearing matters.
Okay. Oh, okay. So, because we used to have those listed here.
They were listed, but
You decided not to? Okay.
that was at my discretion in that
Okay.
if you'd like me to put them back on, I can, but
Yeah, if you
hearing
could.
matters not related to specific complaints.
No, understood. But if you could just list all of the things, however you want to package this, hearings that were referred here and hearings that we initiated, so that we know what the workload is of each committee.
Yes, it's just they were
It's different. I get it.
getting pretty old.
Which is why I wanted to have the dates on there, so we could say either we're going to schedule it next time or let's just close the file. Because at
I'll
some
put it
point,
back on the next agenda.
okay, because at some point, Member Wolf had requested a discussion of social media. Well, that was like a year ago. Let's do that. I mean, it's okay. I'm not.
And
you're
to
not
that
disagreeing.
point, Victor, put it on there at the end, and then put after it, discussion or closed file. Just kind of give us a hint that we should need to, I'm not going to use the expression, but you know what I mean. All right.
And I think we're all in agreement that we want to move things more quickly.
I agree.
Yeah, I'm good with all that. Thank you very much.
Just real quick, the Mooney versus the assessor recorder. I'm trying to remember what we determined at the last full task force.
This was there was a
There were two
violation
separate
found, but there was a different issue in that they did not have an index of records listed online.
Oh.
But that was due to the city administrator's problems.
Right.
They have recently placed it online. I believe the only question that remains is, are they listing the subject matters that they should be listing in comparison to what the state is maintaining?
Okay.
And we asked them to provide links to the index from their thing. Did they flesh out their
Yeah,
process a little bit?
we spent, I think, altogether too much time on this in the full task force last time, and again, it's very frustrating dealing with this particular.
Got it. This particular item was less about the complainant and more about the
Structure.
respondent and what they needed to do to make records available. This thing was not specifically about the PI records and the port and all that. This was about their index of records and
Okay.
procedures.
And I'm seeing that now in the brackets.
But I'm not disagreeing with you either.
So, Victor, just to jog my memory so I don't ask the same question in 2 months when we meet again, maybe put there EOTC is considering the format of the presentation of material from the assessor offices.
Format of presentation.
Yeah, and then colon records retention, and on their website, the records retention, index of records, webpage design, and a comparison and a direct comparison of information maintained by the state versus the assessor recorder. Something like that, just get us right to the heart of the matter.
And I would add to that on both of these items and the other stuff that we'll add back to the list, that we should notify the respondent and ask them to provide that information in advance so that we can have it in our packet.
Written information.
So that they know exactly what the subject of the hearing is, and it's not just, can you show up and talk about?
Yeah.
We want you to show up and talk about it, but we want to do that after they've provided a memo, so we're all very focused on it.
Right. Yeah, and I like that. I think that sort of asking for advanced written material to be discussed by you in person at our meetings should be our standard for noticing, and for order determination, and for follow-ups, and for continuances.
It's a concept, yeah.
Because then they'll have time to say, well, we don't have anything. Like, well, you got 28 days now. Clock's still ticking, whatever it is, just to kind of get them moving along. Because it is the on and the on that, frustrates the complainants, and also makes our numbers look horrible in terms of, caseload and getting things
Yeah. I don't think we're in disagreement on any of this
All right.
stuff.
Okay.
Okay, good.
Just a matter of, we need to tell them this with the orders.
We do.
And with the follow-up, so it's,
The follow-ups would be my notice of hearing. I don't mind doing that.
right.
It's just we need to do it at that time.
And when we send the notice, we should redirect them back to the order that says,
Yeah.
that's what we asked for, we're looking for.
Yeah, so this follow-up hearing is the determination where you were found in violation of X, Y, Z, and where you need to do this, this, and this. This is your opportunity. We expect you to arrive with a knowledgeable representative with A, B, and C documents.
We would need to work on
The
developing a
templates.
new template,
I'd be happy to do that with
a
you.
new template notice of hearing.
Sure. Yeah, send me what you have with your first draft. I'll tweak it, send it back. We can put that in front of either this committee or the full task force, and if we need to have it
I
approved.
think we should
I
leave
don't-
that to you guys to figure out the
All right.
template, but I think you've got good
Yes.
direction for what to fix.
Okay. I'll do templates, you do minutes. Remember, Pilpa, how's
Good
that?
deal.
All right. Okay.
I'll take the high road, you take,
I think you're on the low road.
I think I just,
2011, yeah. you're on the
Thank
low
you.
road. All right.
Okay, next is adjournment.
and there was no public comment on that, right? Okay. Without objection,
This meeting is adjourned.
thank you.